The Supreme Court today hearing arguments in one of its most anticipated cases this session, Childs versus Salazar, centers around a Colorado law banning conversion therapy for children. The counselor says the law violates her First Amendment rights of speech and religion. Let's bring in John Yoo, former Deputy Assistant Attorney General. So the Alliance Defending Freedom has partnered with Kaley Childs. They argued that the ban violates a therapist's right of free speech in conducting therapy sessions. Opponents, including the American Medical Association and the American Psychiatric Association, say the practice doesn't work. Here's part of their filing. Regardless of how it's performed, conversion therapy is ineffective and is associated with harms that include depression, anxiety, loss of faith, and suicidality. For these reasons, laws like Colorado's exist in 25 states and have the support of every major healthcare association in the country. Conversion therapy is used if somebody feels like they're of a different sex than they were born. The conversion therapy is sometimes used to try to bring them back to their original gender assignment. So where do you come down on all of this?
John, this is one of the major cases in what's going to be a big term at the Supreme Court. States generally have the right to regulate the practice of medicine or law in their states. The court just last year in a case called Scrimeti reaffirmed that when it said a state could prohibit gender transition medical treatments. But a state can't go so far as to use these kinds of regulations to control what people say. Even though the government can say you can't do certain medical procedures or those kind of medical procedures, they can't say, but you can't speak at all, that you're not allowed to have a viewpoint. Then the First Amendment protects the right, I think here, of the therapist, Ms. Childs, to say what she believes.
So here's what she said. I want to be able to operate genuinely and create therapeutic relationships that are not hindered by the values and positions of our state. She claims that she has had to turn away clients who are interested in conversion therapy. They also point out that these associations have been wrong about other issues in the past. For example, the American Psychiatric Association, until 1973, considered homosexuality to be a mental disorder. I mean, the science around all of this is pretty fluid at the moment.
That's a good point, John. One of the things that the Childs says, and I think she's right about this, is that if you were going to restrict my speech based on the viewpoint, because notice, speech on the other side saying it's okay to change gender identity is not prohibited. Only speech going one way is prohibited. She's right to say, if you're going to limit my speech, then the government must have compelling proof that what it's doing is necessary to protect health and safety. And as you say, John, the evidence is still out, is not still confirmed. There's still no, I think, 100% consensus on the medical success one way or the other. But putting that aside, I think she has the right to freedom of speech. She's not actually doing anything, no medical treatments other than talking. Think about it this way. Suppose the Confederate states, in their power to regulate lawyers, had said, no lawyer is allowed to make an argument challenging segregation. You can only make arguments in favor of segregation. That, too, would be using professional control over the practice of law as a way to control speech.
And again, the science around all of this is so fluid. We saw that Europe was out front when it came to transgender treatments and hormone treatments. Now they've gone 180 degrees and dialed that back the other way. So maybe there's more to come before the final decision is rendered. And I guess we won't hear from the Supreme Court about this until next summer. But John, thank you for joining us. Really appreciate it.